Good morning. Welcome everybody to Trial from Start to Finish CLE. Welcome to those in the room. Welcome to those online. We had hoped to subscribe this to about 200 people. We are currently at about 285. So by the end of the day, hopefully we will be at 300. We're about split evenly between people live and people streaming. Let me tell you how the day is going to go. You have it in your materials. We are taking it through like a trial on the plaintiff's side with Voir Dire opening. And then we are going to have a trial technology presentation by Richard Serpy, who brought all his equipment in, and it's very cool. And then we're going to have direct examination, cross-examination, and then closing. The fact pattern was given to us by AAJ. It had been created by Donald Deskin, who's now a professor at Duke. It fit our purposes mostly, but we had to make some changes. Two of the changes we had to make was the exhibits were not very good, so we created them from Google Earth, which you can do as well for the roadway. And also the medical illustrations are not of our clients' actual injuries, but they're very close. And I would like to thank Amicus Visual Solutions for providing us with the illustrations that we're using, which are top quality. I think that's it for the, there's going to be close adherence to the fact pattern by most of the presenters, but the purpose is to show you techniques. So there might be some deviation. There might be a lot of deviation from Chuck Zauzig, as he told me he's going to wander and I can't stop him. There's a reason Chuck is last, which is he doesn't listen, especially to when moderators are trying to get him off the stage. Thank you. So this is a new format. We want your feedback. Tell us what's working, what's not. For online, if you email to vtlalive@vtla.com with questions or comments, especially if something is not working in terms of our blocking. We tried to work everything out, but if you're having trouble seeing something, let us know and we will try to accommodate you. We may or may not be able to get to all the audience questions today. If we can't, email them to me, and I will do my best to get them answered by the presenters later this week. Thank yous to Affinity Consulting Group, Josh Hopness. He has come from Columbus, Ohio. He is doing the trial presentation of the exhibits. Again, Amicus Visual Solutions, and Jeffrey Frederick with the Jury Research Group, National Legal Research Group, the Juror Research Division. And I'd also mainly like to thank all of the presenters. I couldn't believe they all said yes. I'm so glad they did. I can't wait to see what they do. So, without further ado, you don't want to hear from me, you want to hear from them. We are going to start with Voir Dire. Barbara Williams. Let me do a quick introduction, Barbara. Barbara practices in Winchester and Leesburg and is able to get results in really difficult places, i.e. the Valley. And one of the reasons she is able to do that is she connects with jurors incredibly. And that's why I wanted to see her Voir Dire presentation. She is a past president of this organization and a wonderful trial lawyer and a wonderful friend. Barbara Williams.
Thank you, Brian. Hi, my name is Barbara Williams, and I represent Dorothy Hiller. Can everybody hear me? Okay. Louis Stoneburner is my co-counsel. Louis is over here. And do any of you know either me or Louis or our client, Dorothy Hiller? Dorothy Hiller, excuse me. I'm going to call her Dorothy most of the time. So this is the part of the trial that I get to ask you guys questions and you all can talk. Yes. Messing with my technique here. All right, I still can't really hear my voice. Is that better, Jeffrey? From the people in the back? Okay. Yeah. There we go. All right, I'm sorry. Okay, so this is the part of the trial, the only part of the trial that you guys get to talk, because the rest of the trial, the lawyers are going to be asking the witnesses questions, and the judge is going to be talking, but at this point, you all get to talk to me. And so I'm going to ask you a series of questions so that I can find out what your experiences are and a little bit about what your life's like. First of all, I wanted to know if any of you guys have served on a jury before. Okay, so we have Ms. Dimitri, you've served on a jury?
Yes, ma'am.
And what kind of jury was it, civil or criminal?
It was a grand jury.
It was a grand jury?
Yes, ma'am.
Okay. And were you the foreperson?
I was not.
Okay. And were you satisfied with that experience?
Yes, I was.
Okay. Did you all convict the person or find the person innocent?
We convicted them.
Okay. And where was that trial?
That was in Richmond.
Okay. Thank you very much.
You're welcome.
And I believe Mr. Freeman?
Yes, that's correct.
Have you served on a jury before, too?
Yes, I did.
You raised your hand. What kind of jury was it?
It was a criminal trial?
Okay. Were you the foreperson?
I was not.
Okay. And what was the verdict in your all's case?
Innocent.
Okay. Where was that trial?
That was in Richmond City.
Okay. Thank you very much. I think someone else raised their hand. Yes. Ms. Leek?
Yes.
You've
Yes.
served on a jury as well. Was your criminal like the other jurors?
Mine was civil.
Okay. Were you the foreperson?
I was not.
Okay. What was the case about?
It was a car accident.
Okay. This case is about a car accident, too. Were you satisfied with your experience?
Yes.
Was there anything about that experience you want to share with us?
Not particularly.
Okay.
There wasn't anything extraordinary about it.
When the jury deliberated, did you all talk a long time about the case?
It was about 4 hours for a 2-day trial.
Okay. And did you feel like you were able to voice your views with the other jurors?
Yes. Mhm.
Okay. Great. Where was that case?
That was in Richmond City.
Okay. Thank you. Is there anybody else on the jury panel that served on a jury before? Okay, so 3 out of the 7. How about, have any of you sued another person? Okay, we have 2 jurors raising their hand. Just so that everybody's comfortable answering, can I have a raise of hands of those of you who have never sued anyone? Okay, great. So, Ms. Horner, tell me about what your case was about.
Well, I was walking across the street one night, just.
Sorry about that.
Sorry. I was just walking across the street with my dog one night, and a car didn't stop, and they hit me.
Oh my goodness.
So.
Are you all right?
I'm okay now. Yes.
Okay. All right. And where did you bring that lawsuit?
I think it was in civil court.
Okay, it was a civil case.
Yes.
Okay. Did you obtain a verdict on your? Did you quote unquote win that case?
Yes, I did.
Okay. And is there anything about that case that makes you uncomfortable sitting here today?
No.
Okay, or feel like you would be more leaning towards the person who's suing since you've sued rather than the defendant, the fleeting trucking company?
Maybe, maybe not.
Maybe a little bit?
Maybe a little bit.
Okay, all right. Well, we can talk about that a little bit later. How about the other gentleman?
Yes, I sued a woman that hit me with her car.
Okay, and you're Mr. Freeman, right?
Yes, that's correct.
When was that?
That was about 15 years ago.
Okay. And did you obtain an award in your case, a money damages award?
Yes, I did.
Okay. And were you satisfied with that?
Yeah, I think so.
And you were satisfied with your lawyer and the whole court system?
Yes.
Okay. Is there anybody on the jury that feels that people shouldn't be able to bring a lawsuit for injuries like the two jurors that just shared with us? Okay. Ms. Groover, you didn't shake your head yes or no. Is there something about lawsuits that makes you uncomfortable?
No, I guess my only concern is that I don't think that people should get exorbitant amounts of money for these sorts of lawsuits.
Okay, all right. So would you listen to the evidence, and if you heard evidence that someone incurred $300,000 worth of medical bills, would you feel that awarding more than that would be exorbitant?
I think I would be able to listen, and I would maybe consider what the details are.
Okay, all right. Is there a certain number that you think is just too much money to award anybody no matter what? Is there a ceiling in your mind that you wouldn't award to anyone?
No, I just think that it should match whatever the damage actually was to them and not be some number that we just come up with to maybe fix some sort of emotional distress that they've had.
Okay, okay. But if someone did have emotional distress and you were instructed by the judge that you were able to award money damages for emotional distress, would you be able to put a dollar figure on that emotional damage with the help of your other jurors?
Maybe if we discussed it, but I think it's difficult to put a price on that sort of thing.
Does anyone agree with Mrs. Groover about that issue? Yes. Ms. Leek, tell me about that.
I just think that multi-million-dollar verdicts, for the majority of that being pain and suffering, is a problem. I agree with Ms. Groover that it should be proportionate and it shouldn't be an arbitrary number that we come up with. It should match along with what's happened.
Okay, it should match the evidence and the damages
in
the case. Okay. How about you? Do you agree with these two other jurors? Miss Bringard, right? Bringard. Thank you.
I'd have to say that outside of the hard numbers from the medical damages, that quantifying pain and suffering above and beyond just isn't something that's possible.
Okay. All right. Anyone else want to comment on that? Okay. And tell me, what do you do? What's your employment? What do you do for work?
I'm a trauma nurse at VCU.
You're a trauma nurse at VCU. Have you ever been involved in any lawsuits as a trauma nurse at VCU?
I haven't been to court to testify, but I work with a number of doctors that have been involved.
And those doctors have been sued before and they're angry about it?
Some of them have been sued. Others have been called to be experts, I think is the word you use.
Okay. And if you served on a jury and brought back an award, would that make you uncomfortable when you go to work with these doctors?
I'm sure that someone would make a joke about it.
Okay. And that would make you uncomfortable?
It might.
Yeah, it's no fun being joked at.
Mm.
Okay. Does anybody else have a situation at work where there's talk about lawsuits? Okay. You know, the court gives us some basic information about your employment, and but I don't really know a lot about your everyday work or your everyday life. So let me start with you, Mr. Vaughn. I have here that you are a teacher.
That's correct. I'm a high school English teacher at Henrico High School.
Okay. How long have you been teaching at Henrico High School?
About 5 years.
Okay. What do you teach?
I teach English.
Okay. Do you like that work?
I do. It allows me to work with young people, and I enjoy doing that.
What grade do you teach?
I teach all the grades through high school, 9th, 10th, 11th, and 12th.
Okay. So you teach English to everybody?
Yes, ma'am.
Okay. And do you have any children?
I have 2 children. I have a son and a daughter who are 2 and 4 years old.
Okay, great. Thank you. How about you, Miss Horner? What do you do for...
I'm a stay-at-home mommy.
That's a lot of work.
Yes.
And how old are your children?
I have 2 daughters. One is 2 and one is 6.
Okay. And so is your 6-year-old in school now?
Yes, she's a first grader.
Okay, great. Thank you. Tell me about your household. Are you married?
Technically, yes. I'm married. I'm separated.
Okay.
Yeah.
What does your, I won't call him your ex-husband yet, but what does your significant other do for work?
He's an electrician.
Okay, great. Thank you. And Ms. Dimitri, it says here you're a project engineer for the Timmons Group. What does a project engineer do?
Well, we manage the whole process when a building is being constructed or land surveying or pretty much anything going on with the project. And we make sure it's on time, it's running on time. We prioritize tasks. We coordinate all the employees that are working on it to make sure they work together.
Okay, great. And is it your job as the project engineer to deal with safety issues?
Yes, ma'am.
Okay. And thank you very much. Could you hand the microphone to Ms. Brigard? You have to tell me. Ms. Brigard, I have here that you are we've already learned about your work as a nurse. I apologize. And do you have any children?
I do.
How many children do you have?
I have 2 daughters.
Okay, great. I see that Mr. Freeman, I'm going to ask him about his work, if you wouldn't mind handing the microphone over. Mr. Freeman, what do you do for work?
I run an auto mechanic shop.
Okay. So it says self-employed here. So it's your own shop?
Yes, that's correct.
Okay. And is there anything about running that shop that makes you hesitant to serve on a jury for a personal injury case?
For personal injury, not necessarily, but the time commitment, it's a lot of time to run a shop. So.
Right. We think this case will last about 3 days. Is there anything about being here for 3 days that's going to give you a problem as a business owner?
I think we can probably manage that.
Okay, thank you so much. Ms. Groover, can you tell me, I see here that you're a student, is that right?
Yes, ma'am.
Where are you going to school?
I go to the University of Richmond.
And how long have you been there?
This is my 2nd year.
What are you studying at the University of Richmond?
I'm in the business school. I study accounting.
Okay, great. Thank you so much. And Ms. Leek, it says here you're a retired criminologist for the Virginia State Police. Is that right?
Yes, I just retired this year.
How long did you work as a criminologist for the state police?
For 44 years.
44 years, wow. Now, I'm a civil lawyer, so I don't know what a criminologist does. Can you tell me a little bit about what your work involves?
Yeah, we study why people commit crimes, so we look at patterns, motives, demographics. It helps law enforcement apprehend criminals. It also helps pinpoint people that may be future criminals so that they could help deter that at the onset.
Okay. Well, one of the things I wanted to explain, since you were in the criminal in the world of crimes and criminal cases, and some of you have sat on a criminal jury, is that in this case, the burden of proof is different from a criminal case. Because in a criminal case, you have to prove that someone committed that crime, beyond reasonable doubt. It's like you've got to prove it. There's got to be no doubt about a person's guilt. But in a civil case, we only have the burden of showing that more likely than not, we have to just tip the scales a little bit that a fact is true or not. So it's very, very different. Sometimes I tell people it's just 51% instead of 100%. So because the burden is different, I want to make sure that each of you are able to apply that burden in this case. We talked about the issue of money damages and whether or not you could award something for emotional pain. So if we prove to you more likely than not that the person had emotional pain, would you be able to hold that burden in this case? Can you show me your hands if you're able to hold the burden to that degree? Okay, thank you. I'm going to let Mr. Stoneburner ask you all some questions now because I have gone through most of my questions.
Stand over here so we don't get the mic feedback. Louis Stoneburner, every time I see a result from him, I wonder why on earth the defense attorneys and insurance companies keep taking him to court. He is a trial lawyer's trial lawyer and, again, gets consistent results in medical malpractice cases. And Louis.
Thank you. I was thinking about this Voir Dire over the weekend and trying to expedite things so that Jeff Bright would have more time to present later. And I came up with one question. I've distilled everything down to one question. So, who here exclusively watches Fox News? Just kidding. Voir dire, they tell me, I took Latin for years, never took any French, but apparently in French it means to tell the truth, okay? So this is our one and only opportunity to speak to the members of the jury to get them to tell the truth about any kind of bias or interest or relationship that they might have with the case. We're not going to try to pick on anybody or make anybody feel uncomfortable or humiliated or anything like that. But both sides, in this case, want to end up with totally independent, totally objective, and totally impartial jurors, believe it or not. And so what I want to do is I want to delve into 4 areas of your background: your employment, your family, your politics, and your religion, and see if there are any sort of any kind of currents or advocacy or prejudices that stem from your background that you might even not realize that you have. So the context of all of my questions are in the personal injury setting. We're pleased and privileged to represent Ms. Hiller, who was severely injured in an avoidable accident. This is a claim for money damages, not just for economic losses like medical bills and lost wages, but also for the intangibles that some of y'all had a little bit of a reservation about, and we're going to talk about that also. Things like pain and suffering, emotional distress and mental anguish, disfigurement and deformity, adverse effect on activities of daily living, enjoyment of life, and things of that nature. Not just accrued through Wednesday of this week, but into the future. And you're going to hear evidence about life expectancy. So the first thing I'd like to talk about is employment, and co-counsel Barbara did a great job in getting each of you to, describe what you do and what your place of employment's like. But my question's more general, and that is, in your employment, have you ever had occasion around the water cooler or in the coffee room or whatever to talk about cases like this where someone who claims to be injured by the alleged negligence of a third party has brought a lawsuit. Have there ever been discussions about personal injury claims? Yes, ma'am. You're Ms. Ringard? Ringard. You're a nurse, correct?
Yes.
Okay. What discussions have you heard at your place of employment?
General discussions about how lawsuits tend to clutter up the ER with diagnostic tests.
Okay. Have people expressed in your presence the fact that they believe, at least at VCU ER,
Yes.
that there are too many lawsuits brought by allegedly injured people?
Yes.
Okay. Have they talked about whether the suits are frivolous or otherwise?
Yes.
Have they talked about runaway verdicts that are ridiculously high?
Yes.
Have you participated in those discussions?
A bit.
Have you joined in those discussions and advocated basically the same thing? Too many lawsuits, too many are frivolous, and too many result in way high runaway verdicts?
More along the frivolous side. As a nurse, we are part of the diagnostic team when people come into the ER, and there are sometimes tests that may be unnecessary, but we have to run them to make sure that everyone is safe in the medical profession.
Okay. Now, you don't make the decision, the medical decision, as to what tests are done for the patients, correct?
No.
Those are done by MDs.
Yes.
And so the MDs have been leading this discussion that there are too many claims, some of them are frivolous, some verdicts are too high.
Yes.
Have there been any written policies, procedures, or protocols about testing sort of in reaction to all of these lawsuits?
There's been no written material.
Okay. Now, does that influence your view as a startup in this case? That is, you know, you've got sort of two strikes against Ms. Hiller by virtue of your background and many, many discussions at work to this effect.
Well, Ms. Hiller didn't come into my ER, so I don't know her circumstances.
Well, I'll just represent to you that she went into other ERs and, you know, underwent lots and lots of tests and surgical interventions and things of that nature. Would she still fit in that category of being, you know, another automobile accident patient who's come into the emergency room and burdening, you know, the people in the emergency room with a bunch of tests?
I don't know what tests she had done or what she needed.
Okay. Does anybody else have that kind of exposure at work? That is, you know, discussions with your peers or your staff or your superiors about personal injury lawsuits? Yes, sir.
Well,
Mr. Freeman?
Yes, sir. Well, working in an auto body shop, we see a lot of our work comes as a result of an incident that you know, people often, you know, are involved in lawsuits. Somebody's paying for the damages, and somebody did the damages. But so we talk about it a little bit, and then I mentioned earlier that I was in a lawsuit, so there was a lot of talk about it back then. But
okay. Well, it's a good thing for you economically that there are automobile accidents and things like that.
Unfortunately.
Does it have any impact today, tomorrow, and Wednesday in terms of how you view this case coming in?
I don't think so.
See, what we're trying to find is whether anyone here is going to be, for whatever reason, have a level of discomfort with either the plaintiff's case or the defendant's case without hearing any of the sworn testimony, the evidence, or the court's jury instructions on Wednesday. So that's what I'm aiming for. Anybody else here, strictly looking at the employment theater, ever had or ever engaged in discussions with anyone at work about the concept that there are just too many plaintiff's lawsuits? Yes, sir.
Well, it wasn't discussion about too many plaintiff's lawsuits, but before becoming a school teacher, I was a writer for the Times-Dispatch. Okay. And there were a lot of stories, local stories that I covered that, you know, dealt with lawsuits and sometimes ended up in lawsuits. Now, that didn't come to a conversation about too many lawsuits, but we did discuss, that lawsuits were occurring, civil lawsuits.
Did you actually go into the courtroom and the peanut gallery and observe trials?
Sometimes, very little. When I first started out, I would go into the courtroom a little bit, but I wasn't like the courtroom beat writer. I was more of a local interest story, but sometimes I'd have to go in there for a day or so.
Okay. Did you ever observe medical evidence being put into the case in a civil case?
I did not. The cases that I cover are mostly, local housing discrimination cases, things like that.
Okay. But your beat, if you will, did include personal injury civil cases, correct?
It covered things that turned into civil cases, if that makes sense. Local car accidents and things like that is what I would cover that would sometimes turn into a personal injury case.
Did the Richmond Times-Dispatch have a viewpoint or flavor about personal injury cases, whether they were good, bad, or indifferent?
Not that I could tell. I personally am indifferent. Usually, there's usually a decent claim if a suit's coming forward.
Okay. So nothing from that employment background would inhibit you from being totally independent, objective, and impartial in this case?
I don't think so, no.
All right. I next want to turn to the family. Thank you. And all of us have discussions with all age groups in our families and hear lots of viewpoints around the dining room table and that kind of thing, and from grandparents and parents and uncles and aunts and everything like that. And so I'm strictly asking, in the family context, not trying to pick on anybody, but have there been discussions about frivolous plaintiff lawsuits for personal injuries? Yes, ma'am. Ms. Lee?
My husband just retired last year. He was a police detective for Richmond City. So the majority of both of our careers, we talked more about criminal trials, but there were 2 instances where he was sued, once by someone that he was arresting that said that he injured him in the process, and once by someone that was shot by him in the line of duty. So when both of those came up during his career, we talked about the frivolousness of it, and both of those were dismissed before it ever got to a trial point.
Before it got to trial?
Yes.
Do you know whether was it your husband?
Yes.
Okay. Mm-hmm. Whether your husband was deposed under oath in a case like that?
I think he was. I think he was deposed, and I believe his partner was deposed as well.
Was he bitter about that experience?
I wouldn't say he was bitter. He was a career police officer, police detective, and so this wasn't the first instance where this had come up. It had happened to other people in the department as he had gone through. So
he felt like he was the innocent victim.
Yeah, and the majority of people that he dealt with never had this. For it to be 2 instances in his 45-year career, he didn't think that that was an alarming amount. So.
Okay. And he obviously knows you're in court today.
Yes. Mm-hmm.
Does he know that you're sitting in a potential civil case as opposed to criminal?
We didn't really talk about it. I've been called before, and I wasn't chosen for a criminal jury, I think, because of my background and his. So I kind of figured that it would be a civil matter, but we didn't talk about it specifically, no.
Did he give you any guidance to stand tall for the defendant or stand tall?
Oh, absolutely not. I think with both of our careers, you have to be impartial, right. And that's kind of the attitude that I take with jury duty as well.
The court's going to instruct you on this in a bit, but do you all realize that you can't go home tonight and talk to your family or call your employer or your peers at work and get any kind of, backstop guidance from them and keep them up to speed and all that?
Yeah, absolutely.
And you can't discuss it among yourselves. And, very importantly, you can't get on the internet and Google me and Barbara and Ms. Hiller and defense counsel and the judge or any of the medical or legal issues in the case. Does everybody understand that?
Yes.
All right, I want to turn briefly to the political arena. And we don't care whether you're Libertarian or Republican or Democrat or something I hadn't thought of. That doesn't really matter at all. It's just whether or not your political activities have in any way influenced your view of the world as it applies to protection of interests of plaintiff versus protection of interests of someone in the business community and their employee. So my question is real simple. In the political context, would you indicate to us whether or not you've engaged in discussions about the merits of personal injury lawsuits? Yes, ma'am. Ms. Groover?
Yes, sir.
Would you explain that to me, please?
Well, just under your terminology, I tend to be more conservative, I would consider myself. And so I think under that ideology, I would say that I think I shared this earlier, that I just don't really think that we should be giving people hundreds of thousands of dollars for a car accident per se, if the damage doesn't really equate to that amount.
Not trying to be personal, but do you watch Fox News?
I've seen it.
All righty. Okay, so have you ever chimed in on that discussion, either electronically or in person, that is supporting that conservative view that limits the amount of recovery that an injured plaintiff can obtain in a personal injury lawsuit?
Certainly in person with family and friends, just when you see these cases coming up either in the newspaper, on the news, seeing the amounts that people are getting or even asking for in some of these suits.
Okay. Anyone else hold political views one way or the other that would possibly favor the plaintiff, possibly favor the defendant in this case? Yes, ma'am. Ms. Horner?
Well, I was in a personal injury case myself, and I was hit by a car. And just my own views, I really do think that when this kind of stuff happens, someone needs to be responsible, and they should have to pay for the emotional damage and for the whole case, because that really does alter someone's life.
Thank you very much. And I think in Barbara's questions and responses that Ms. Leake and Ms. Groover and Ms. Bringard, sorry, all sort of expressed views to the effect that there should be some artificial ceiling, glass ceiling, cap on recovery for general intangible injuries that are claimed, like pain and suffering, emotional distress, mental anguish, and things of that nature, correct? Did I read that properly? Okay. Can you tell me why?
I don't subscribe to one political party. I would say that I'm more independent, and in my 65 years of life, there have been a number of elections that I haven't participated in. But in some of the speakers that I've heard that were primarily Republican candidates, they've discussed tort reform and just the sheer number of lawsuits, and some that aren't necessarily, I don't know, the word valid maybe. I don't know that I could place a specific number on the cap, just as well as I don't think I could place a specific number on someone's pain and suffering, but I think that there must be some level of accountability that would keep it from going over the limit there.
Okay. And what is the limit in your view?
That's what I say. I don't know what the number would be. I just think that it needs to be proportionate, and there should be some checks and balance there, so that people don't get these front page headlines in their ideas of what the number should be.
Speaking of front page headlines, are you familiar with the McDonald's hot coffee case?
I am.
You guys are too young for that probably, but are you familiar with that case?
I am, yes.
Okay. Do you know anything about the evidence that was presented in that case? And that's the one
I know that people use that as an example for a frivolous lawsuit, but I also know that her damages were pretty high. Her injuries were pretty graphic. And I also know that McDonald's had a lot of warning before then about what was too hot, I guess, for the coffee. So the fact that they hadn't done anything about it, I think, makes them more accountable. But she also had significant injuries that resulted in real damages as well.
Have you ever seen the documentary?
I have, yes.
And you know that Stella Liebeck was severely injured, that she was the 700th victim of the scalding hot coffee that McDonald's was serving, and that she underwent major league plastic surgery, including multiple skin grafts. Okay. I shifted to the cap before I got to religion, but does anyone else have any views on what the maximum recovery should be? Yes, ma'am. Nurse Bringard.
Like bring the guard.
Okay.
I think as far as the damage is capped, just because I don't know what's going to happen tomorrow, you don't know what's going to happen tomorrow for anybody in the future. And as far as projecting into the future, I think that there's a higher power that takes care of that. And so at maximum, a ballpark number would be for me $250,000.
Do you believe that that is a statutorily passed number, that there's a law in Virginia to that effect?
I'm not sure if there is one or if there is one on the way.
I'll just tell you, there is not one in Virginia. Now, for those of you who adhere to the belief that there should be a glass ceiling or a cap on recovery, would it differ if the plaintiff was 1 year of age versus 81 years of age? Would it differ?
Well, subscribing to the fact that I don't know what's going to happen tomorrow or in the future, no.
Ultimately, you're going to receive judicial notice recognition of the mortality table in the Commonwealth of Virginia, and the court's going to recognize that Ms. Hiller has a life expectancy of roughly 20 years. You're going to hear evidence about her incapacitating injuries and associated disability. And the trial does end on Wednesday, but she continues living thereafter. And so my question to all of you is, are you going to be able to award future damages on the basis of the medical evidence, the recognition of the life expectancy table, and the sworn testimony of the witnesses? I'll start with you.
I might have trouble.
Okay. Can you quantify that?
Again, I'm not sure, since I don't know what injury she suffered or where she is currently.
Well, does it matter if someone loses a thumb versus an arm in terms of, you know, an intangible general damage number? I mean, does 250 apply regardless of whether the arm's gone or a thumb's gone or you have a whiplash injury or 2 limbs are lost or the person's paralyzed or blind? Does the cap always apply?
I'm not sure.
Okay, thank you. All right, lastly and briefly, I'm going to turn to religion. And again, we don't care whether you're non-religious or Catholic, Baptist, Jewish, Muslim. It really doesn't matter. But our concern is whether any of your religious exposures have put you on a path where you may be more preferential to either the plaintiff or the defendant. And I'll give you an example. We tried a case some years ago in which a 9-year-old child died. And it was a medical malpractice case. And the allegation was that the underlying condition had not been timely diagnosed and treated. Through our investigation of potential jurors like yourselves, we learned that one of the members of the jury probably believed that everything was preordained and that absolutely nothing would have changed the course in the case and the child would have died. She did not answer a single question on my voir dire, and then I asked the court for permission to ask her one question outside the scope, outside the presence of the other jurors, and I asked her, do you believe everything's preordained and that this child was called home to God? And she said yes. And the judge kindly excused her. So that's the kind of thing I'm looking for, whether there's any fiber from your religious background that would in any way lead you to prefer finding for the plaintiff as opposed to the defendant. Have we covered all of your potential discomforts in bias and interest? Thank you.
Louis, thank you very much. Barbara, thank you. Now I'd like to call to the stage Jeffrey Frederick with the National Legal Research Group. Jeff is a juror consultant who consults throughout the country. We're lucky to have him here today. He has written an incredible book, Mastering Voir Dire and Jury Selection, which I think is 300 or 400 pages long. Jeff?
You go by weight.
Yeah. I've done a number of focus groups with Jeff. He's made some great calls and interested to hear what he has to say about what he's seen and voir dire in general.
This works better? Okay, great. Thank you very much. Actually, I want to, first of all, let's give them a round of applause to get up in front of their peers. Even the jurors are clapping. That's good. That's always a good sign. Actually, they did a wonderful job. So it's really, you get up here and go, well, how can I say anything of value to you, which is my whole goal. And it becomes limited, but I think we have something to work with. And I want to actually respond, Lewis, his last thing that he did here was really cool. I like that. And that is Lewis drew upon his prior experience and going, I had this case where this woman, I had to question her outside the presence of the jurors and, is everything preordained? And she goes, yeah, he brought that into this case. What we recommend is that if you have an example like that or an experience like that, the bad answer, that you go ahead and don't wait for it to come out from the jury because you may never hit it. So go ahead and take that answer and then create a question from it and then address it to the jurors. So I thought that was really good. A couple of general things is that you'll notice that they both were comfortable in front of the jury. I may not have joked as much, but we're also in a live demonstration here. But we have, what they were able to do is that they were able to have a conversation with the jurors. And they also spent the time with the jurors. Sometimes in Voir Dire, we perceive ourselves to be rushed. The judge wants us to go faster or whatever it is. They took the time. And if someone gave an answer that they needed to follow up, they did. And that's something that I really want to encourage. They also both have a good way of just being able to relate one-on-one in a non-judgmental manner. And that's one they both were communicating is that, whatever your opinion is, we want to hear it. And so that's particularly useful for them. Let's see here. They also took advantage, and we have like 3 particular people in back that were not particularly favorable to the plaintiff, and they identified that, and they did focus on them. They were good, and I'm sorry, most of my talk is going to be, you guys were good. So if you can stand it, then we'll continue on. But they were good with the follow-ups. In fact, Barbara at one point in time saw somebody, and this is really, I encourage you to do this, saw somebody non-verbally and either respond or not respond. I can't remember exactly, but she saw what this person did and then followed up with it and didn't let it go. So and she found that information as a result of it. That's something that, that's what we're here for, is to find out. They both did a good job. Barbara is really good with the reinforcing. Thank you, appreciate that. You and I take that for granted. Like, well, of course we say thank you, or that's interesting, or whatever the clinical phrase that we're going to be using with these folks. But whatever, they want to be acknowledged, so we need to reinforce them for opening up, even if they give us bad answers. The one thing particularly, okay. Okay. I thought you were going to leave a business card. Jeez. Thanks. I appreciate that. Okay. Another thing that Barbara did that was good that I really encourage you to do is that she asked a question. She got, I think it was it about lawsuits? I'm not sure, but she asked a question, got maybe one person or 2 people to raise a hand, and then she flipped it. And she said, well, okay, let's do it the other way. Let's say, how many of you have not had? And that is a really good technique. because what happens is that we tend to ask questions of jurors where only a couple people raise their hands, and this was a somewhat artificial demonstration in that we only had 7 people here. So, we were able to get these people to talk, but if you have a group of 20 or 30, which we all sometimes face, it becomes more difficult. And what she was able to do is she flipped the question, which then forced other people to be engaged. They had to raise their hand and say, okay, that's it. And she also lets people know that you're going to participate no matter what. You can't just sit there and sit on your hands. So that's something that's good. In fact, thank you. On my pages, I was going to ask each of you, we changed the order of critique, I was going to ask each of you to tell me what your goal was. And I think that let's go ahead and do that because I think that is of value.
Okay. You might want to stand away from Jeff so we don't get feedback.
So my goal was to get everybody to talk, but these are law students, so that wasn't hard at all. It was almost too easy. So I tried to use the technique that actually Jeff taught me of, when you ask a question and only 2 people raise their hand, then flip it around because, I want everybody to raise their hand. I want everybody to talk. That's why I asked them about their jobs and what they do every day. And I didn't do that very artfully, but I want every single person to look me in the eye and talk about something, hopefully about something personal.
Right.
But I've served on a jury, and I knew the lawyer. I owned a piece of property with the lawyer, and I didn't tell the judge that. I had to ask at the end of Voir Dire, so I understand how awkward it is to be sitting on that panel. It's really awkward.
Louis.
I normally try medical malpractice cases and have for a long, long time. And the voir dire is vastly different in that context for lots of reasons. So what I was trying to do, I like to do to tell the truth thing. And I normally say, you've been asked to be a constitutional jury under the 7th Amendment of the United States Constitution to give a fair trial by jury to both litigants. So I try to kind of put pressure on the panel members at the outset in a nice way, hopefully, that this is the one and only opportunity for them to tell the truth to us as to whether they have any underlying issues with the case, whether it be from employment, family, politics, religion, or something else, so that we can identify that one person who believes everything's been preordained. Now, going into a trial, I've got a book about this thick on the panel, and we get the jury list 2 business days prior to the start of trial, and we do a tremendous amount of research. Can't call anybody or anything like that, but in a lot of cases, I know your political persuasion. I know what bumper stickers are on your car, what the tax assessed value of your house is, whether you've got a hunting license, lots of little things like that we put together a composite picture of each potential juror and grade them. We do it on Sunday afternoon, A, B, C, D, F. And then half of them have disregarded the summons and we've got brand new jurors. But it does give us some working basis. And we're looking for tort reformers, jury nullifiers, people who, regardless of what the evidence will be in the case, have already decided the case, which is grossly unfair, and that's the object.
Excellent. Thank you. I'm going to make a couple other points, and I'm sure Brian will have some questions. Maybe we'll entertain some from the floor. Another thing that I like to see is when you do this kind of polling of the jury and you talk to one juror, we saw it somewhat today, is being able to say, has anybody had a similar experiences with Bringard? And she was a popular person today. Is to when she espouses the kind of anti-lawsuit, frivolous lawsuit kind of thing, instead of saying, does anybody else have views on this, you can also say, does anybody agree or have had a similar experience with Ms. Bringard? so you can actually, because someone may respond to, anybody else have another opinion? Well, she already said it, I don't need to respond. But if you can go ahead and with a significant answer like that, is go ahead and see if anybody else, we didn't hear much from the front row on these issues. I mean, it was still good. But I would go ahead and see if you get a key response, how many agree with that? And be able to go ahead and say, well, what about you? What about you? What about you? And then do a in essence, a poll. Okay, how many agree with this, to make sure you've got everybody who voted on this thing. The one thing that and Barbara may agree with me is that when you got, I think it was Bringard that talked about the emotional distress and how that she was concerned about damages in that area, and I know that you're kind of saving stuff for Lewis, because Lewis had to get up and say something, and so I recognize that. But one of the things that you followed I have these issue with emotional distress, and then you start talking about the judge's instruction. The judge is going to instruct you that you have to do this. Are you going to be able to do that? That I think could be it was worth pursuing. I tend to bring the judge's instructions later on in the questioning process, so I can make sure I find out that you had a problem. I would probably find out how you would grapple with coming back with money for emotional damages, whether or not you would require, whether or not the plaintiff would have to kind of convince you more. Provide you with more in order for you to return hundreds of thousands in emotional distress. Some way of getting what's in her brain out before we go into something a little bit further, or telling them what the instructions were. And also, Barbara, you have such a great job. You do such a great job with relating personally. You actually, with juror number 1, she was like 44 years in the criminology, and you just, wow, that's and if you're on the receiving end of that, you're kind of going, oh, that is kind of cool, I'm going to talk to you, they'll do that. So that I thought that was really a nice touch of relating to them and getting them open to you. I could probably say more, but I will.
If you have more, you're welcome. We're actually okay on time. We're going to have some questions, obviously, but.
Okay. I think that probably the biggest thing that I want to encourage the audience is that we saw 2 very good people taking the time to talk to jurors, not feeling rushed. The one thing that they didn't, this is all thrown together, is that I think that they both could benefit from having, and we didn't have the kind of podium that they wanted, or something like that, in these free-form discussions, particularly when you get into lawsuits and frivolous lawsuits and that kind of stuff, it's easy to kind of forget key questions that you might want to have. For example, how many people think that jury awards are just simply too high? And to go ahead and yes, they did a really good job on pursuing the 3 most critical ones on the lawsuit issue, but this is more ammunition that they can use to mount a challenge for cause. Because quite frankly, we're going to need a challenge for cause. With a jury, we're going to need some challenges for cause, and so what we want to do is to find as many levers that we can pull that we can use to convince the judge that this should be a challenge for cause. And so that's what I would encourage. And also when we go into the challenge for cause, that we're talking not about being fair and impartial. And in fact, I very rarely heard fair and impartial, which is really cool. When Brian and I talk and stuff like that, it's just like, those words, unless the judge is holding a gun to your head, those words should not come out of your mouth. You know, we're talking about, are they going to require us as plaintiffs to do something that we don't have to do? That is, if our threshold is 51%, are they going to say, you know, with Mrs. Brinkard, is she going to be like, you know, are you going to need to be a little bit more convinced? You know, maybe, you know, like 60%, you know, 70%. You really be more convinced in order for you to return hundreds of thousands of dollars in the face of the evidence, and you know, some question that allows her to go, yeah, you know, I can't really live with that 51%.
And a great question for cause on that is the non-economic damages. All jurors will give you, I can follow the law at 51% on medical bills and lost wages. But if we pressed Ms. Groover here on whether she would require more than 51% for non-economic damages, I can almost guarantee you she would. Because she has a hang-up, and so many jurors have a hang-up with that. And they really just, they don't think it's fair to have to, at 51%, make the defendant pay a bunch of money. Yeah, if you're going to show me non-economic damages, I want it beyond a reasonable doubt.
And go ahead.
Yeah, and if you drill down on that, you're going to get a motion for cause. Because, I mean, you'll get them off for cause. Because, you know, once they admit to needing more, the judge can't keep them on.
And the same thing would apply with the total damages. You know, what Brian said is really important. And you start seeing, you know, there's a couple areas that we can use the preponderance of the evidence test as a way of getting some people off because we don't want them and we're trying to find some way of doing it. Well, one area is, would they require you to do more than you are legally required to do? Another thing that they didn't have time to get to is that, and Lewis alluded to this, and I'm sure if it was, you know, a longer period and he didn't feel the time pressure, he would have broken down the damages. The way I view damages in personal injuries is the way I select juries in capital cases. You know, you go mitigation shopping in capital cases, many you know, to see whether or not they could actually treat each one of the mitigators and consider it fully, etc. Well, I want to do the same thing with the non-economic damages. I want to talk right now, pain and suffering, and I deliberately use pain and suffering because that is the red flag for your Fox News jurors and people who have it against lawsuits. You know, the red flag is pain and suffering. But there's other aspects. There's aspects of deformity, the quality of life, these kind of aspects. And this way, you can actually build up something to where someone can say, well, they have problems with pain and suffering. They have problems with quality of life. They have problems with providing money for scarring or that kind of thing. And you can start building up a kind of a total package.
And with the Walpole decision where you can run through all of those in closing, you can say to the judge, look, the jurors are going to have to consider each of these damages, so I'm entitled to go through all of them. And that's one of the hardest things about voir dire, especially in Virginia, is you've got judges breathing down your neck. And you just, as much as you can, be strong and say, I need to get through these because I need to make sure these jurors aren't demanding more from me than I'm required to prove.
And another thing about being strong is that what I found, I've been doing this since '75. I've earned this gray hair. What I have found is that attorneys who are confident, not arrogant, but confident in, well, of course I should be asking this question, that they're more likely to get that question asked and answered than if they're kind of like, well, this is kind of an unusual question. Let me see if I can ask it. It's like, no, you've got to walk in there like, well, of course. My next question is question 23, boom, and you just do it. And this way, if you start waffling on it, the judge starts going, no, wait a minute, what's going on here? I want this thing to move fast. And the jurors start having problems with answering your questions. And a judge is more likely to let you continue if he or she sees a jury responding. See, the jury is paying attention, they're responding, we're not getting a lot of dead silence, that kind of stuff. So, take advantage of what Brian said about being strong and being confident.
Yeah, and last point, before we open up for questions, have other people in your firm either in the front row or at the table. So much of this is body language, right, guys? And you can't see everything, and you're focused on the person you're talking to, and panel, you did great. And one of the great things you did was nods when somebody was saying something that they agreed with. And you might not be able to pick that up if you're the one doing the questioning, but us sitting down could see that, and that is very, very telling, is people's body language. So, the more people who can watch, the better. We have our first question from online. It's for you, Barbara. You asked a question about exorbitant fees or verdicts, and you threw out $300,000. Was that on purpose, or was that just a number you picked out of thin air?
I thought it was a number close to the plaintiff's medical bills, but I must confess I don't
No, that's
know.
about right.
Okay, that's why I used that. I was trying to use a real number in the case.
And so you generally peg it to kind of the special damages somewhat in a particular case?
Exactly.
Okay.
Yeah, I mean, I wanted to ask if they would award $60 million if the, I was thinking of Jeff Bright, but I thought that's not going to fly. With this case, $60 million's a little bit much, so.
Questions from the audience? Yes. Let's see. Let me...
This might be a tricky question, but what are the one or two biggest adjustments you'd make for Voir Dire in federal court as opposed to state court?
I think it was to the panel. It was about federal court versus state court. The glib answer is that you just watch the federal judge do your voir dire for you in federal court. But I will let these guys answer.
Well, my knowledge is a bit dated. I think the last case I tried in federal court was in 1992. So I'm not sure I'm a real good source, but I don't think I would vary it. I would stick right with the game plan.
Okay. Any others between Jeff? You do a fair amount in federal court.
Well, the federal courts that we've been involved in recently have really put the clamps on attorney-conducted voir dire, and that they basically have allowed follow-up to questions, but not much. What I would do is that I would take advantage. Oftentimes, if we're not allowed to address the entire group, is that on the follow-up questions we're given a little bit more latitude. And so I would definitely try to ask questions about, about caps and other aspects that are key to your case when you're together up there, because the judge is more likely to allow you to ask that type of question.
Next questions from online. What role in voir dire is there for using your questions or comments to undo misperceptions? Is that possible? How should that be done? Lewis, you were starting to go into the McDonald's verdict. Amanda had heard about it and actually had heard about the facts. But a lot of times you will get jurors who will say, yeah, that was just ridiculous. $3 million for hot coffee. Are you going to take that on, or are you going to just say, take what she says and just go with it?
No, what I typically do is challenge the basis of the opinion. Have you read the trial transcript? Have you seen the graphic photographs of the thermal third-degree burns bilaterally on the thighs? Do you understand she underwent 7 plastic surgeries, couldn't walk for a year and a half, blah, blah, blah. And, oh, by the way, she was a 700th victim of, scalding hot water served by McDonald's. So I challenge them. I'm sort of nice, but my goal is to identify the bad guys.
Well, and that's, I mean, you call it jury selection, but it's really jury deselection, right?
Yes.
You are just looking out for these deaf jurors who aren't going to give you a fair shake, one way or the other. I mean, just like, people who are 100% for us, honestly, they have no business being on the jury either. But it's about identifying these deaf jurors who automatically will shut you down before they hear a first word. So, Jeff, about challenging perceptions?
Yeah, well, I think that it's important, but I want to make sure that your first reaction is not to, and I don't think that Lewis was saying this, your first reaction, the first person that mentions McDonald's, you don't drill down on that person about how they're wrong for that. You find out how many, and I think Lewis would do this too, you find out how many other people have heard of the McDonald's case to make sure you find out all the other potential red flags there before you actually do this kind of, I'm now going to tell you why you're wrong, because that can shut other people down also.
Yeah, and if you're in a particularly hostile environment, if you don't think you can change the attitudes with that, Jeff hits the nail on the head. You want to make sure you're not telling them why they're wrong. I mean, you need to do it in a way that Lewis was kind of going down the road of explaining what the case was about. In the back. Can you use the microphone for the people on the...
Just repeat the question.
You could...
Complex litigation attorney in Richmond. This is really for Mr. Frederick, whose book I do want to look up. One thing you did not touch upon is punitive damages, and I have several cases, 1983, and assisted living cases and defamation cases where we have won on punitive damages, and I think it's something that the nurse juror would actually vote for, where, say, there's 3 people on the floor for 112 patients and there's a fall. And I was just wondering what kind of questions would you want to ask on Voir Dire, where, say, there's an elderly patient and we're not just talking about an eye or a toe, but we're talking about the overall horrific conditions of the facility where the individuals are forced to urinate and defecate in a corner, or, there's no staffing or no feeding, or the conditions at a jail are so horrifying that somebody's bleeding out in a corner from an injection or an overdose of medication, or things like that, and you're asking for about $1 million, and it really has nothing to do with Fox News or political, but that a local community is going to want to storm the gates once they hear that their parents are paying $4,000 a month to have this horrible place in their community. That's the questions I'm interested in, because I have several of these cases in the works right now.
And it's a delightfully complex scenario that you're presenting. One of the things that you start off by talking about punitive damages, and so so we'll start there. And so if you have a punitive damages case, one of the things that you need to ask jurors is whether or not they think punitive damages do more harm than good. That is, for people who are against punitive damages, that is a red flag for them. That's right, and we've heard people talk like that, and that's why we would include it in voir dire. You'd also want to take a look at since you're going to have such horrific, which you posit are going to be horrific conditions, you're going to want to talk to the jurors about the obligations, the duty of the care providers. Yes, the nurse may be very sympathetic to you, but we want to find out basically how strongly do jurors feel about what the obligations are to the elder care facility, to the prison. When you start getting into prisons, you start ending up with some interesting dynamics there. You may not be able to ignore politics when you get into prisons, but you're going to want to find out what are the expectations of the jurors for how the people will be treated there, so that you can then see whether or not their expectations are going to be violated as badly as you think they are. But that's going to be a key, is to find out what the duties they believe the duties are. So I would definitely go down that route, and you still have all the other kind of damages questions that you normally have. You know, that has to be there, and whether or not they can ring the bell on that, we need to find that out.
And kind of part and parcel of this, to what degree are you all interjecting facts about your case into your voir dire? I mean, some jurisdictions you kind of try the case, right? In New York, there is no judge. I mean, you're literally almost trying the case to the jury. We obviously can't do that. But to what extent are you all injecting the facts of the case into the voir dire?
Well, I used to inject a lot more until I saw Eric Oliver speak, and he talked about setting up the case, you know, the rules of your case and what's right and wrong before you tell the jury about your case in chief. So I've changed my voir dire a little bit based on his teachings.
And one way to get at that, a great question is, what makes you good at your job? Because you will get from that kind of basic values of why people, why they work hard, what they do to make themselves good at their job, and that will start to introduce those values to the rest of the jury. Lewis.
I haven't seen Eric Oliver so far, so I try to do my opening statement as far as I can in the voir dire for a little redundancy.
So do you get...
I get lots of objections.
Okay.
But yeah, I'm an advocate.
Yeah, but I mean, Jeff kind of touched on having the confidence when you're asking the questions, and you had that here. Lewis, I mean, you're not going to get a judge who is going to really jump in on you when you're that confident. I mean, so. I think we have time for one more question. Yes. Valerie,
if you could raise
your hand.
When you ad-lib questions that aren't on the voir dire list, does the judge have the right to automatically shut you down?
Well, normally where I practice, you don't give the judge a voir dire list. So at least where I practice, perhaps in other places you don't, but in Northern Virginia, we don't give voir dire to the judges.
We try them all over, and some venues, some judges do request a preview of your voir dire. I always have a written voir dire available that includes everything in the event that I'm put to that test. But I'm with Barbara. It's very rare that we have to share that with the court.
Yeah, and having the, in your mind, why is this relevant? Why is this relevant to the voir dire? If you have a quick, strong answer to the judge and say why it's tangentially related or why it's related to the question you just had, they'll generally let you go. Okay, last two questions from online. Ever ask, if you had to decide the case now for either the plaintiff or defendant, who would you fine for? I don't know if you all, I think you will probably get shut down by a judge or a defense attorney if you try that. But I think there's another way you can get at it. Is anybody sitting here today, and they basically did, are you leaning more towards the plaintiff, more towards the defense? And using that kind of hedging language, you're more likely to get a response than asking if people are completely dug in. Barbara asked some of the jurors if they had kids, but not others. Why, Barbara?
Oh, that was just me ad-libbing. I was trying especially for the, I started with the at-home mom because I'm sort of going on work, and then, the at-home mom, that is their work, and So I was just transitioning.
Yeah,
from
and
one
they
to
had the face sheets, so they knew how many kids they had. When I sent Lewis the face sheets, he said he was going to take a non-suit.
Yeah, I mean, we knew the children, but again, my goal was to get them talking. So
Yeah.
it was just me trying to ask a question I knew that they would answer.
People love to talk about their kids, so anything you can do to get, break the ice at the beginning, and kids is a great way to do it.
Can I give one final tip? And I can't take credit for this. This one of my paralegals came up with it. It's probably not novel, but for every trial, we have stickers that have each juror's name and information on it, and we have a seating chart, and we're able, and we do it with the master panel also. So half the time, 15 people don't show up, and you've got 15 new people. Well, we've got the stickers for them also. And so if someone's struck for cause, and we would move to strike all three of these ladies back here for cause.
Not strike her.
I don't know about that. But if someone's struck, and Joe Smith comes in as the new juror, we put that sticker on top of the stuck person.
That's great. That's great. Thank you all so much. That was wonderful. And thank you very much to the panel. You guys were great. Thank you.